right, welcome everybody. My name is Jonathan Baker. I'm the Senior Director of Education at TIA. Glad you guys could join us. This is kind of a last minute thing we asked Mark to do, talk about the SCOTUS case from last week. Got a couple of housekeeping things that we need to do first. This live stream is sponsored by DAT, so I wanted to make sure we got their commercial in early, so here we go.
Freight isn't static, it's dynamic. It evolves. Today, freight brokers have more on the line, and they need to act faster than ever before. Rates move, capacity shifts, and customer expectations never slow down. That's why, for decades, brokers have trusted DAT. Now, we're evolving to serve you better. We've brought together innovative companies and brilliant minds obsessed with solving broker problems. And we've accelerated how quickly ideas become products, all to create a one-stop shop for trusted capacity, automation, and real-time insights. That means the largest, most secure carrier network in freight. It means full visibility to give your customers peace of mind. It means simplified execution to keep pace with a fast-moving industry, and real-time market insights to anticipate changes before they happen. DAT Freight and Analytics. We take the uncertainty out of freight.
Awesome. Thank you to DAT for sponsoring today's live stream. A couple of housekeeping things, then Mark, I'm going to hand it over to you. We always start with our antitrust statement. So discussion, comments, and presentations during TIA functions must not, 1, refer to any past, present, or future rates, prices, or anything related thereto. 2, include any reference to marketing strategies. 3, include any discussion of boycotts of any person, product, or firm. Or 4, inhibit any members' employees from discussing employment with other member companies. Things you hear during the meeting that are confidential and private to TIA should not be shared publicly without its prior consent or used against or in competition with TIA. All right, a couple of things. If you want to ask Mark any questions, we're going to get to those at the end of the live stream. I think we're probably going to go around 30 minutes today, so get those in quick. You can comment on LinkedIn or YouTube, and we'll see those comments come in. And then I'll come back on and moderate those for Mark at the end of the live stream. And then if you could, use this QR code up in the top left-hand corner of your screen. Give us a little bit of feedback. If you have ideas for future live streams, topics, things you want to hear, people you want to hear from, put those in there for us, and we will make sure to get those in on a future live stream. But with that, Mark, I'm going to hand it over to you.
All right. Well, thank you very much, Jonathan. Thanks to all of you who could join today. For those of you who don't know me, Mark Blubaugh, I'm co-chair of the Transportation and Logistics Practice at the law firm of Benesch Friedlander. And I also have the honor of serving as outside general counsel for TIA. So it's great to be with you today to share some thoughts about the oral argument that was held before the U.S. Supreme Court last week in the Montgomery case. I had the privilege of attending in person in the courtroom, sitting in what is known as the well of the court, just about 25 feet or so from the justices, where the members of the U.S. Supreme Court bar are permitted to sit. And for those of you who haven't visited the U.S. Supreme Court in the past, just to paint you a picture, I mean, the courtroom it's quite intimate. It's a beautiful neoclassical design, ivory-colored marble walls, large iconic columns, heavy red velvet curtains. You have this large raised mahogany bench at the front where the justices sit. So a very formal and intense environment, so to speak, at the Supreme Court. So what is this case? Let me remind everyone the nature of the case that we're talking about. It's a classic fact pattern that brokers unfortunately face. In this particular case, there is a shipper who retains a broker, C.H. Robinson, to arrange for the interstate transportation of a load of plastic pots. C.H. Robinson contracts with a federally licensed motor carrier to perform the transportation for this customer. Motor carrier goes to point of origin, picks up a load in Ohio. As the motor carrier is passing through Illinois, the driver veers off the road while he's transporting the load, collides with a tractor trailer that was stopped on the side of the road. And the tractor trailer in that instance was being driven by a Sean Montgomery, who was injured as a result of the collision. So he ends up commencing litigation in federal district court in Illinois. He sued not only the motor carrier and the driver, but also sued C.H. Robinson and certain affiliates of C.H. Robinson. And the claims that the plaintiff brought were really twofold. One, that C.H. Robinson had negligently selected this particular motor carrier to perform the transportation. And second, that C.H. Robinson was vicariously liable for the negligence of the motor carrier and its driver due to alleged control exercised over the motor carrier and its driver. So eventually, C.H. Robinson moved for summary judgment, saying, hey, we don't need a trial here. We'll move for summary judgment on both claims. One on the vicarious liability claim, and the court granted it and said, look, the facts here that have been introduced don't really support the level of control that would give rise to vicarious liability. So the district court judge threw that claim out. CH also said, hey, with respect to the negligent hiring claim, we argue that those are preempted by the Federal Aviation Administration Authorization Act, the F4A. It's a big mouthful. And I'll go into that in a moment, but the court grants that motion and says, C.H. Robinson, you're right. This claim is thrown out as well. So the plaintiff had lost. Plaintiff appeals to the Seventh Circuit Court of Appeals, loses the appeal. Appellate court says that the lower court got it right. And then, interestingly, both parties sought review from the Supreme Court of the United States. You would expect the plaintiff to do that, but C.H. Robinson, in the interest of obtaining some finality on this critical issue, also asked the court to review the case. And last fall, on October 3rd, the Supreme Court announced that it accepted the case for review. The court only accepts a tiny fraction of cases submitted every year. There are 7,000 to 10,000 requests usually submitted, and they accept maybe 60 or 80 cases, and this was one of them. So what is this F4A statute that CH relied on in defending its case? So just to give you a quick little bit of history, if you step back in time to the late 70s, Congress was trying to deregulate the airline industry and enacted a statute called the Airline Deregulation Act. The goal, again, was to add some efficiency, reduce costs by deregulating an industry. And one thing that Congress was concerned about was, if it's deregulating at a federal level, will the states try to re-regulate at the state level? So in that legislation, Congress said, hey, we're making it clear that we're going to preempt any state efforts, whether through laws or regulations or otherwise, any efforts to regulate the prices, the routes, or services of an air carrier. That way, the states couldn't interfere with that interstate commerce. So if we fast forward to the 80s, as the trucking industry began to become deregulated, and then into the 90s, we get to the mid-90s, and the F4A was enacted. And what Congress did was say, hey, when we pursued deregulation with the airline industry, we included this preemptive language, and it really served a purpose. It worked at the end of the day. It achieved our congressional goals. So we're going to use that as kind of an analogical template. We're going to mirror some of that ADA language when it comes to surface transportation in the trucking industry and the brokerage industry. So that statute was passed in 1994. It was slightly amended in 1995 when the Interstate Commerce Commission was terminated altogether. And brokers were added to the protections that were originally established in the F4A at that point in time. So it provides this additional protection to brokers and says, look, if a state is going to enact a regulation, a law, or something that has the force of law that relates to a price or a route or a service of, among other things, a broker, that's going to be preempted. And this was aimed at creating uniformity for the transportation industry through this preemption so that everyone could have some predictability. What are the rules of the road, so to speak, as we operate in interstate commerce across the nation? And the statute preempts not only state laws that are enacted, positive laws that a legislature enacts or that a state agency promulgates, but also court judgments, jury verdicts, any other kind of manifestation of state tort law that might exist in a given state. And this preemption is important for a variety of reasons. It comes up in these bodily injury cases that we're talking about today in the Montgomery case, but it also affects cargo claims. It's a form of preemption available to brokers where brokers don't have certain other types of preemptive defenses. And for instance, the Carmack Amendment applies to carriers and not to brokers. This form of preemption applies interstate as well as intrastate, which is significant. And while it doesn't preempt claims for breach of contract, there are other statutory exceptions in the statute. And that's really the core of what was at issue in the Montgomery case. There is the so-called safety exception. And in section C2 of the statute, it says, hey, this broad preemption that we created in the F4A, it's not going to apply in the instance of the safety regulatory authority of a state with respect to motor vehicles. And the plaintiff's personal injury bar has been arguing that that exception, that language that I shared with you, really saves from preemption claims against brokers for negligent selection in personal injury cases. That's the core argument and what was before the court in this given instance. And the reason it made its way to the U.S. Supreme Court is because there has been a split in court treatment of that exception across the nation. At the federal level, we had 2 different circuit courts say, yes, we think the safety exception does save those claims from preemption. In other words, brokers are exposed in those jurisdictions. That's the 9th Circuit and the 6th Circuit, so covering many of the West Coast states, Alaska, Arizona, California, Montana, Nevada, Oregon, Washington, etc. And then here in the 6th Circuit, where I'm at, in Ohio, also Michigan, Kentucky, and Tennessee. On the other hand, 2 other federal circuits had said the contrary and said brokers should be protected by this statute, and the safety exception does not save those claims from preemption. That's the 7th Circuit and the 11th Circuit. So we're thinking Illinois, Indiana, Wisconsin, and then down in the Southeast, Alabama, Georgia, Florida, etc. And state courts and lower federal courts have been split on this issue as well. So bringing you up to speed to the oral argument, what was happening between October 3rd and the present, Montgomery filed their merits brief at the beginning of December. Various amicus parties filed in support of Mr. Montgomery. There was a Institute for Safer Trucking, the American Truckers United, various state attorneys general, some law professors as well, filed amicus briefs saying the petitioner, Mr. Montgomery, was correct. C.H. Robinson filed its brief in mid-January, and there were various amicus briefs filed in support of C.H. Robinson about a week later. So the TIA, the U.S. Chamber of Commerce, the National Retail Federation, 2 other state attorneys general, some law professors, some large shippers like Amazon and Wayfair, Honda, and also, and significantly, the U.S. Solicitor General. The government chimed in, the federal government chimed in on behalf of C.H. Robinson in support of its position. Mr. Montgomery filed his reply brief in mid-February, February 13th, and then oral argument was held less than a week ago. It was last Wednesday, March 4th. So what are some of the takeaways from the oral argument? What did I observe? What caught my attention? A couple of things. Number one, I think that TIA and its members should be very proud that Justice Kavanaugh gave a shout out to TIA's amicus brief. It was very gratifying to see that the TIA's brief captured his attention. And I'm going to read just one excerpt from what he had to say from the transcript for those of you who didn't listen or didn't read the transcript. He says, I think that the amicus brief of the Transportation Intermediaries Association, particularly pages 20 to 24, really go in detail of if tort liability extends to them, how are they going to assess and evaluate the safety of drivers in a particular trucking company? How are they going to figure out, do they have an alcohol and drug issue? How are they going to figure out English proficiency, which of course is a critical issue at the current moment that's being discussed? How are they going to do this is the real concern that's raised in that brief and by respondents that I think, is something you need to respond to. And he directs that question to Petitioners Counsel. So it was very encouraging that the voice of the broader brokerage community was heard by the Supreme Court. At least Justice Kavanaugh had carefully read the brief. And I did not think that counsel for petitioner, as highly talented as he is, really answered Justice Kavanaugh's question adequately. Justice Kavanaugh hit that same theme a few other times through the course of the oral argument. And each time, petitioner essentially suggested that it was pretty easy for brokers to comply, that they simply needed to hire what he referred to as quality carriers, not hire fly-by-night carriers, but never defined what he was talking about, never defined the same. didn't specify what he called the hard questions should be that brokers should supposedly be asking of carriers in order to avoid liability. And Justice Kavanaugh pressed him regarding those issues. With respect to English language proficiency, petitioner did concede that it presented a complicated question, is how we put it, but maintained that brokers simply, needed to make sure that carriers have an adequate testing program. Again, with no appreciation for what that might involve. How would, as a practical matter, a broker go about doing that? And the real underlying issue is, for those of you who may have litigated these cases or been involved in them, whatever you do as a broker is never enough for the plaintiff's personal injury bar. There's always something more you should have done, something else you should have looked at. And then on the other hand, if you do too much, you go too far, then they claim that you are vicariously liable because now you are controlling the motor carrier. You have inserted yourself into their operations, that you're essentially serving as their outsourced compliance department or safety department and the like. And so you get it coming both ways. So that was one main takeaway from the argument. A second issue that was apparent to me through the course of the argument was with respect to proximate cause. There was much more discussion about proximate cause than I expected to be the case during the course of the oral argument. And some of the justices appeared to believe that rather than relying on preemption, brokers can simply rely on proximate cause principles to escape from these cases. Because, well, if the brokers are so attenuated from the carrier's operations, can't you just win on proximate cause? But that's, beside the point to begin with. The F4A preempts that duty element in the first instance. You should never even get to proximate cause. But when we look at it, if we talk about brass tacks, telling a broker to defend on proximate cause is cold comfort for most. It almost inevitably will become an issue of fact for the trier of fact, whether that's a judge or a jury. And the broker will have spent exorbitant amounts of money and resources defending the claim by that point that proximate cause can be dealt with at the trial court level. So that was another theme, so to speak, another issue that was front and center, was this proximate cause discussion. A third area that I would share is that many of the justices had good questions, I would say, about subsection B1 of the statute. And that particular subsection of the F4A, which preempts claims related to intra-state rates, routes, and services, is not subject to the so-called safety exception at the heart of the Montgomery case. And the petitioner conceded that the distinction here was a bit anomalous. And that he made it clear he wasn't arguing that the legislative distinction made any sense, but that it existed. And when he was pressed by Justice Kavanaugh in particular about whether or not petitioner had a brilliant way of reconciling what he claims is an anomaly, the petitioner acknowledged that he had none. Now, CH's attorney, on the other hand, pointed out that it was really unthinkable and absurd that Congress would have wanted to allow states to regulate interstate transportation, but not transportation within their own borders. Very counterintuitive. Doesn't make a lot of sense. And in fact, on that same point, Chief Justice Roberts, he only had one question during the entire oral argument, and it was very much towards the end. And he asked the Deputy Solicitor General about this apparent anomaly and said, what is the explanation here? And the Solicitor General pointed out, look, there is no anomaly if you construe the statute in the way that C.H. Robinson and the brokerage community thinks it should be construed, because claims based in negligence or otherwise against brokers would be preempted regardless of whether they're interstate or intrastate. And that provides the context for which or by which the court should be interpreting the so-called safety exception. So it was an interesting discussion about that subsection B1, and I think it's a good point that I hope the court will give more consideration to. I think a fourth kind of takeaway from the oral arguments is that a number of the justices and counsel placed, I think, unnecessary, unwarranted emphasis on the Federal Motor Carrier Safety Administration's capabilities and resources. There was an effort to paint a picture where the FMCSA is falling down on the job and the like. And even if that were the case, it wouldn't be an excuse to shift a federal statutory responsibility on companies in the private sector. Since 1935, Congress has made licensure and regulation of motor carriers a federal obligation. And like any federal agency, I'm sure that FMCSA would love to have more resources to perform its functions. But I also imagine that the agency would contest claims, protest that it is unable to perform its essential functions. The FMCSA has lots of staff doing lots of great work every day and always striving to improve. So I think that was an unfair picture that was painted. There were a number of other arguments, obviously, that came up through the course of the discussion. Some of it was based on plain language about what does the phrase, with respect to, that's used in C2 really mean. I searched through the transcript. That phrase was used 85 times in the course of the 90 minutes there. And of course, the position of the freight brokerage community is that phrase really massively limits the scope of the preemption or the scope of the exception in C2, because the Supreme Court has previously held that language with respect to, as used in C1 of the statute, massively limits the scope of preemption. So there has to be some limiting principle here, in other words, and that the natural limiting principle is a distinction between direct and indirect links between state law and motor vehicles. Otherwise, no law would be preempted, since every possibly relevant law here would have some kind of vaguely indirect relationship to motor vehicles. And including that phrase with respect to motor vehicles would be superfluous. It wouldn't have any operative effect. And likewise, the other exceptions in C2 would be kind of redundant, because they're all at least indirectly related to motor vehicle safety in some fashion. Now, the plaintiff's view of that, and the position that they took during oral arguments, essentially is that, hey, that phrase with respect to, it's synonymous with relates to, concerns, involves. It should be construed broadly, and that a state law requirement to exercise reasonable care in choosing a motor carrier, it concerns or involves motor vehicles, because the purpose is to protect the public from unsafe motor vehicles. That's their position, and they say, the fact that the Congress used related to in the preemption provision and with respect to in the exception is really meaningless. The different prepositional phrases can be used in a misplaced pursuit of stylistic elegance, so to speak. They put that in their brief. They really didn't get into that during the course of the oral arguments, though. So that was another issue that popped up throughout. There was some discussion of the legislative history and what led to this in the first place. If you read the House conference report when the F4A was enacted, it makes it clear that the state regulatory authority over safety was to remain unchanged. It wasn't granting more authority to the states. And before deregulation, Congress heavily regulated motor carriers and reduced the power of states to do so. States couldn't decide, for instance, and can't decide what interstate motor carriers could or could not operate in interstate commerce. And if you allow these tort claims to proceed against brokers, it's a backdoor way of allowing the states to determine which motor carriers can or cannot operate in interstate commerce. And as a result, it offends the principle. And there was discussion about insurance requirements that the ICC looked at in the 80s and said, hey, brokers aren't exposed to bodily injury claims. Therefore, there shouldn't be any financial responsibility on the auto liability side of the exposure. So that was another fundamental point that was made. And then there was just a lot of other public policy that was woven in during the course of the oral arguments, concerns about this parallel regulatory regime that allowing these types of claims to move forward would create, would mean that brokers will continue to be and increasingly will be named as defendants in every case involving a motor carrier where a broker was involved. The possible negative effect it would have on small motor carriers and and particularly new entrants to the market, how are they going to ever get business? They would be excluded from the market because a broker won't want to work with someone that doesn't have a meaningful track record. You'll want to go with the biggest, largest, longest established carriers in the industry. Those types of points were made throughout as well. So that was the gist of it. I will say, before I open up to questions, the attorneys that argue the case, they are masters of their craft. Paul Clement, representing the petitioners, walked up with one sheet of paper and never really needed to look at it. And though I disagree with his client's position, obviously, he engaged the court in a very effective way. The Deputy Solicitor General seemed very comfortable. CH's attorney did a good solid job. So, and while it was a very solemn environment, we had silence 10 minutes before the arguments began. The advocates were, in certain respects, a little bit more conversational than I may have expected in the first place. And it was interesting just to be in the room, watching the justices' expressions, their gestures during the course of the oral argument. Much of which is pretty apparent from the transcript, but it's interesting to see, the incredulity of Justice Kagan when she says, come on, how could negligence claim against a broker not be with respect to motor vehicles, or Justice Kavanaugh's kind of, I would say, skeptical facial expression when petitioner's counsel said, oh, it's easy for brokers to protect themselves. But the bottom line is, I think, not sure how one could sit through an oral argument at the U.S. Supreme Court and not be impressed with the quality of the U.S. Judicial system. It's not perfect, but it's certainly very, very solid. The final comment I'll have is that we expect a decision. We know that a decision will issue before the court summer recess in late June or early July of 2026. Could come earlier. There's no need for the court to wait until June, but that would be at the latest. And while I haven't personally argued before the Supreme Court of the United States myself, I've argued cases in state and federal appellate courts, and I have learned over time that it is devilishly difficult to predict outcomes. And so you don't want to read too much into the questions of certain justices. I've spoken with members of the bar on both sides of this issue since last week. There's a wide divergence of opinions from both sides as to how it played out, what the likely outcome will be, and the like. And keep in mind that the oral argument is simply one piece of the puzzle. The justices have extensive merits briefs that they're reviewing, amicus briefs that various interested parties submitted. There's going to be internal conferences of the justices as they evaluate and discuss this subject. At the end of the day, not surprisingly, I hope that the justices in the course of their post-oral argument reflections and deliberations will reach the right decision in this crucial issue. So with that, Jonathan, I know we only have a minute or two, but is there anything you'd like to address?
I don't see any questions, Mark. I mean, as always, great job. We appreciate you taking the time to get us back up to speed on this topic. I know everybody wasn't able to watch oral arguments online. So, TIA always likes to bring somebody in like you to kind of recap, keep everybody up to date on what's going on. And I'm looking forward to seeing you in a couple of weeks out in Phoenix for Capital Ideas. It'll be a good time.
It'll be a conference.
Yeah. So again, thanks to our sponsor, DAT, for putting this on. We really appreciate it. Anthony will be back to host on Thursday with Nick Dengels from Sync Logistics Training. They're going to talk a little bit about, common training mistakes that people see at freight brokerages and how you can overcome those things. But until then, Mark, I did it. We kept it on time. We will see everybody next time. Thanks, everybody. We appreciate it.
Thanks for the invitation. Take care.